Today, I'd like to talk about American Axle versus Neapco. And this is actually a reasonably interesting case in its own right because it applied Section 101 to driveline propeller shaft manufacturing, which is obviously a little bit different from software or biotech inventions where you generally see 101 applied. But rather than talking about the case itself, I want to talk about what could happen if the Supreme Court grants cert, because they've asked for the solicitor's views on the matter, and that's usually a sign the case has a good chance of being heard. Um, I think everybody would be very interested in what happens if there's a Supreme Court case. Obviously, there's a lot of ambiguity, a lot of concerns about Section 101. I've seen articles out there saying the Supreme Court should grant cert so that it can kind of fix the mess that we're currently dealing with. And what I would like to do is explain why I think the Supreme Court granting cert probably would make Section 101 worse. The jurisprudence kind of even more of a problem, more ambiguous than it already is. So I guess maybe it's a little bit contrarian, but I actually think the Supreme Court granting cert would not be helping. I think it would make things, again, just make things a bit worse. And I guess let me step back. I think part of the reason people want the Supreme Court to take up American Axle is that, there's this idea they don't take cases just to affirm them. And so if they do take it, they're likely to reverse. And if they reverse it, that means they'd have to put some kind of limits on the current, just pretty amorphous Section 101 analysis. But I think this is probably not right. The Supreme Court, okay, you can say they don't take cases just to affirm them. On the other hand, it did that in both Alice and Bilski, which were both, 101. Those are the two most recent software 101 cases. Now, you could argue, hey, those were special cases. The PTO basically had teed up Bilski for Supreme Court review, so, that's a little different. And for Alice, the Federal Circuit was so fractured, it basically couldn't even come to an opinion, right? There was an en banc, and they just had like one sentence saying, hey, we affirm, and then mountains of concurring and dissenting opinions. So it's almost like there was a circuit split. And now you don't have that. On the other hand, the Federal Circuit isn't as fractured as it was in the Alice opinion, but there's still very significant differences between panels on how to apply Section 101. You get lots of dissents. There was a dissent in American Axle. And so I think the Supreme Court may look at that and say, yeah, it's not necessarily as bad as Alice, but we don't necessarily need to let it get that bad before we step in. Also, I think that people saying, hey, the Supreme Court, if they step in, they're going to reverse, they're going to put more limits on it. I think that's a little bit myopic because, okay, so the patent bar, or at least the part of it that pays attention to this stuff, there's been a lot of criticism of the way 101 is applied. It's too ambiguous, it's amorphous, it's unpredictable. But the outside world is not really focusing on that. What I think the outside world is more focusing on is like patent quality and patent trolls and bad patents. And actually, there was a hearing last month before the Senate Judiciary's Intellectual Property Subcommittee just dealing with bad patents, basically. And I think the Supreme Court really is much closer in outlook to the Senate Intellectual Property Subcommittee than it is to the part of the patent bar that's really concerned about 101. In any case, my feeling is if the Supreme Court does take up American Axle, it's likely to do so in order to emphasize that the Alice Mayo analysis that has generally been confined to software and biotech should be applied to other types of inventions as well, rather than fundamentally clarifying or making any changes to the application. But okay, let's say I'm wrong, right? I mean, I can't predict the Supreme Court. There's all sorts of new justices. Who knows what they're going to do? So let's say they do take it up with the goal of significantly clarifying Section 101. American Axle is a lousy case for it to take up if it wants to make things clearer. First of all, the claims in American Axle were found ineligible because they were supposedly directed to a law of nature. And so right off the bat, it doesn't really present a good case for clarifying because, to my mind, one of the biggest problems with Section 101 jurisprudence right now is that it does not define what is an abstract idea. And since American Axle wasn't about abstract ideas, it doesn't really give an opportunity to clear that up. Also, because American Axle came through the courts rather than through the PTO, it wasn't analyzed using the Patent Office's framework, which I think is probably the clearest. It's certainly the most structured framework that we've got right now for applying Section 101. And so the result of that, however, is that if they make any significant changes, it's not going to be with respect to that framework. It might completely undermine it. It might be, totally orthogonal to it. But ultimately, any big changes, because they wouldn't even have the opportunity to say, yes, we affirm this framework, are likely to require major revisions to it. Now, does that necessarily mean it'll be a big step backwards? No, not necessarily. But, we've seen what the Supreme Court has done in the past. I think the smart money is, step backwards. A big change is likely not to be a big change in a positive direction, just because that's not what we've seen in the past. We've seen a lot of ambiguity, a lot of just uncertainty injected through 101, and I don't see any real reason to believe that's going to be different, again, because they're not looking at the framework that I think is provided, to the extent there's any certainty or predictability, where that's really come from. Now, I guess the question is there any potential for good outcome? There's always the possibility they'll replace it with some meaningful, logical, predictable framework. I think that's so unlikely I can safely ignore it and pretend that's simply impossible. Are they likely to make things worse? Yeah. But there is another possibility that I think is out there. So they could leave things essentially unchanged in terms of the substance of the analysis. And I think that's actually pretty likely because I don't think they want to get into the weeds. They didn't define abstract idea before. I don't think they're going to want to define it now. The Supreme Court likes talking in sort of broad strokes, leaving it to lower courts. That's what they did before. And I think we're just going to see the same kind of a thing. But I think what they would do if they take up American Axle, I think, is it most likely? Yeah, it seems at least reasonably likely that what they'll do is they'll take it to endorse applying 101 across the board, not just to software and biotech. All right, so what happens then? Well, obviously, it's chaos for everyone. But maybe the chaos will lead to Section 101 being applied a little more rationally. And in support of that optimism, I guess I'm going to draw an analogy to the broadest reasonable interpretation rule, which is also a little amorphous. It didn't really historically seem to provide much of a rule at all. It was more just the broadest possible interpretation almost, when it was only used during prosecution. However, once it started being applied in inter partes review proceedings, the Federal Circuit started issuing opinions that found broadest reasonable interpretations that are a good deal narrower than I would have expected from the way it had been traditionally applied in prosecution. And what I can take from this is, when you're not looking at a situation where you have an extremely broadest reasonable interpretation, using that to advance the policy goal of facilitating patent examination, then you start narrowing it in scope. And I think similarly, if Section 101 starts being applied across the board rather than just in areas where, being very aggressive advances sort of, I'll call it unstated anti-software, anti-biotech policy preferences, the Federal Circuit may find ways to make it easier to establish eligibility because aggressive application wouldn't be sort of consistent with a pre-existing long-standing policy. It's a thought, right? Something of a long shot, but given the Supreme Court's track record, I think it's probably about the best we could come from them hearing American Axle. Anyway, I'd love to be proven wrong, and right or wrong, I don't think we're likely to see anything for another year, probably two. In the meantime, I wish everybody good luck dealing with Section 101 and in patent endeavors more generally. So thanks a lot, and I guess I will talk to you all in the future.